Congratulations. So my name is Andy Levy. I'm a trial lawyer from Baltimore. I also teach at the University of Maryland School of Law.
Hi, good afternoon, and good to see you again. Congratulations on making it to Monday. I look forward to chatting again. As you may recall, my name is Ben Glickman. I work for the California Attorney General's office, but much more interestingly, I'm a We the People alumnus, lucky enough to be on a national championship team way back in 1995. So still the highlight of my legal career.
Good afternoon, Virginia. My name is Gus Chen. I'm a municipal judge for the city of Holiday in Utah. Congratulations on making it to Monday, and I look forward to a good discussion this morning.
Please introduce yourselves and your teacher.
Hi, good afternoon, judges. We are Unit 5 from Richmond, Virginia. Our sponsor is Mr. Sam Almschneider, and I'm Ronit Jain.
I'm Michael Kish.
I'm Sadie Turner.
And I'm Drew Beckett.
So let me get to the question. Unit 5, we're going to do question 2 today, which begins with a colloquy between some jurors. 9th juror, the facts are supposed to determine the case. And the 10th juror says, don't give me any of that. I'm sick and tired of facts. You can twist them any way you like. Know what I mean? And the 9th juror says, that's exactly the point this gentleman, indicating the 8th juror, has been making. Why are juries required to render a unanimous decision rather than a majority decision in most criminal cases? To what extent, if any, do jury trials ensure due process as stated in the Constitution and Bill of Rights? To what extent, if any, do jury trials reinforce founding principles? You may start anytime you wish.
In Federalist number 83, Alexander Hamilton wrote, "The friends and adversaries of the plaintiff convention, if they agree on nothing else, concur at least on the value they set upon trial by jury." Hamilton asserts the importance of jury trials, which can also be found in Article 3 of the Constitution and the 6th and 7th Amendments. Jury trials were valued by the founders, but they create complications for the modern legal system. Trial by jury theoretically ensures principles such as popular sovereignty and rule of law, but also invites bias from the public, jeopardizes the 6th Amendment's guarantee of speedy trial, and is costly. These complications can infringe upon a citizen's right of due process. Therefore, jury trials must be reformed so that they may enforce the founding principles they theoretically protect.
Popular sovereignty is protected through jury trials because it involves citizens serving in the otherwise less accountable judicial system. Furthermore, jury trials reinforce rule of law by holding governmental officials accountable for their decisions. However, these principles pertain to the theory of juries, not their contemporary reality. Jury trials are costly in both time and money, which leads most defendants to settle in plea deals. This undermines the possible benefits that the theory of jury trials presents and short circuits to other steps of due process. Plea deals should be limited, with bench trials encouraged as an alternative, and barriers such as soliciting the government to have a bench trial should be eliminated.
Jury trials have already been reformed through legal precedent. The Supreme Court ruled in Ramos v. Louisiana that all state criminal juries must be unanimous in order to convict. This overturned the precedent set by the 1972 case Apodaca v. Oregon, where the court held that an Oregon law allowing convictions 10-2 was constitutional. The decision in Ramos, coupled with Rule 31 of the Federal Rules of Criminal Procedure, ensures that all criminal juries must be unanimous before conviction.
Criminal trials have also abandoned sentencing by juries after it became clear that judges were less likely to impose unduly harsh sentences once the jury had already determined guilt or innocence. Therefore, jury trials have before and can again help to ensure that criminal defendants receive the due process of the law enumerated in the 5th and 14th Amendments.
The centrality of unanimous juries to due process lies in the fact that unanimity safeguards the requirement that the state prove a defendant's guilt beyond a reasonable doubt, a standard firmly established in Miles v. U.S. The combination of reasonable doubt and unanimity standards limits convictions and forces government prosecutors to uphold fundamental procedural rights protected by the Constitution.
Another due process right protected by jury trial is the 6th Amendment's guarantee of a public trial. Juries in nature are drawn from the citizenry, so they play a crucial role in ensuring that a trial does not occur behind closed doors. Public trials are critical to preventing a regression to pre-revolutionary America, in which admiralty courts without juries convicted Americans with no checks on their power.
Although the founders intended for juries to protect the rights of American citizens, there are some inherent disadvantages in the current system. Since unanimity is a requirement of juries in all states and federally as per Ramos, the possibility of a hung jury is more likely. This could infringe on an individual's right to a speedy trial, as a mistrial would prolong the process of reaching a verdict.
Another potential weakness of juries is that they are composed of ordinary Americans, who are more likely to factor public opinion into their decisions, fail to understand legal concepts, or possess hidden prejudices than an unbiased judge or lay judge, which European democracies like Germany use. An additional disadvantage is the difficulty of controlling the role of public opinion in jury fact-finding, recently demonstrated in the Boston bomber and Derek Chauvin cases.
Despite these weaknesses, jury trial remains essential to the fabric of American democracy to ensure fundamental rights of Americans and promote democratic ideals in every facet of the government. Above all, our Republican government should strive to protect these fundamental rights, and unanimity is an essential part of this vital ecosystem, as it best ensures clear conviction of a decision that can drastically alter an American's life. To further safeguard these rights, jury trial should be reformed by limiting the use of plea deals and extending access to bench trials, lest the institution that has been a part of the backbone of our Constitution since its ratification continue to decline.
You're muted.
Thank you very, very much. And let me start off the questioning by asking you at least twice in your opening advocated for the, if not the elimination, the reduction of plea bargaining. Plea bargaining is a critical part of the system and doesn't necessarily work to a defendant's disadvantage, particularly if a defendant, if there's overwhelming evidence of guilt and the defendant wants to acknowledge responsibility and just argue in mitigation of sentence. So what's so bad about plea bargaining?
I would argue that while the theory of plea bargaining certainly can help defend or ensure a defendant's rights, the actual practice of plea bargaining is heavily abused by prosecution attorneys who tend to either overcharge defendants or threaten them with severe sentences, even life sentences, if they attempt to take their conviction to a trial. And in doing so, that's a violation of the defendant's Sixth Amendment rights to a fair trial, because they're sort of forcing defendants, backing them into a corner and making them take plea deals when that's not really the defendant's best option.
There's also a staggeringly large amount of innocent people who do plead guilty because they're threatened by the prosecution and they're scared that a jury will convict them, even if they haven't committed a crime. So they're still pleading guilty to and receiving a conviction of something they didn't do.
There's also a reason that the founders put due process into place. Plea deals just go around the process of due process, and that's extremely important in our judicial system. So if plea deals continue at such a large amount, then
what about the plea bargaining system in which before a guilty plea is accepted, the judge must find that there is an adequate factual basis for the plea? What about that violates due process?
I would argue that it's not a violation of due process. However, it's not necessarily advantageous or even fair to defendants most times, because judges don't have to obey the deals set out in plea deals. And again, prosecutors can lie to defendants to get them to plead guilty to more serious offense.
I think also a potential solution to this problem is to fund more money into the public defender's hands. Oftentimes, defendants have to resort to using public defenders who often are overcharged with cases that more than they can handle. So I think funding more money into public defender's office would be advantageous and maybe help solve the issue of plea deals.
I want to shift gears a little bit. In your opening, you talked about how jury trials ensure the Sixth Amendment right to a public trial. But the most important part of the jury trial, the deliberations, where the jury actually makes a decision, for the most part, that's secret. Do you agree with that policy? What are the advantages and disadvantages of it?
Well, I would argue that one of the advantages of secret jury proceedings is that jurors are not afraid that their decisions, which might be controversial in the community or go against maybe community values, are going to be released to the public. So jurors are free in the privacy of a jury room to make decisions based on the facts of the case, rather than trying to incorporate any kind of public opinion there. While at the same time, juries, by virtue of being citizens of the United States rather than some government official, keep trials from being behind closed doors.
I also think this concept of keeping trials behind closed doors is extremely pertinent, especially with the expanded media coverage of these trials, and especially in trials in which public opinion is swayed heavily in one side or the other. We can look at the Derek Chauvin case and Boston bomber cases as examples of this. Public opinion was swayed heavily in one side of these cases, and if jury decisions were kept public, then that could actually endanger the jurors because public perception was so kind of heavily swayed to one side.
What about a circumstance where the jury deliberations reveal that a juror was biased, racially biased? gender bias, was getting paid by the prosecutor, all kinds of egregious scenarios you can think of. Shouldn't that be public? Shouldn't we know about that to ensure due process?
Well, to get at the first part of that statement, which is racial bias in the jury, the standard established under Batson is a relatively low burden of proof for defendants to challenge a jury's or a juror's racial bias. It just has to be some kind of showing that is automatically taken as true unless it can be proven that the juror was not racially biased. So sort of a lower standard for proof that a jury incorporated some kind of bias or some kind of misconduct helps to ensure a check on that system. But I don't think that overrides the value of allowing jurors to deliberate in secret.
The ruling in the Nebraska Press Association case allows the press into the courtroom for the proceedings of the trial, and that's the only place that they should be. The impartiality of a jury should be protected higher than the press in this case.
I'd also like to add on that the process of voir dire really is meant to be instituted to protect the trial from having jurors who have racial biases, or have other biases like personal views that might affect their impartiality. So I think through the process of voir dire, if we strengthen the process of voir dire, we can help avoid such situations.
Let me jump in with a question based on what you had said just recently. US citizenship is a requirement of a jury service. Now, to have a true trial of one's peers, if you have a non-US citizen criminal defendant, should a legal permanent resident of the United States be allowed to serve on that jury despite not having US citizenship?
I would absolutely believe that legal permanent residents in the United States should be allowed to serve on juries. They're members of the community just the same as citizens. They're supposed to be here. They're integral parts of our community, and to deny them from serving on juries just based on the fact that they haven't been here long enough or they haven't met the quota for citizenship is unfair to a large portion of the community.
Would you be in favor if the defendant is under the age of 18? Would you be in favor of including jurors who are under 18?
No, I would not, because a large concern about the jury process or system is that Americans are often uneducated about legal issues. And if adults are uneducated about these legal issues, then how can we expect 16 or 17-year-olds to be educated about these legal issues? At that point, that would really be dangerous, as juries are often susceptible to hearing lawyers use like flamboyant language or really sympathy as an appeal instead of really looking at the law. So I think that presents a completely different danger that we should try and avoid.
I absolutely disagree. I don't think the age is as much of an indication of education as we think it is. But I do think that for 16 or 17-year-olds to be able to serve on a jury, the right to vote should also be extended to them. But I think that it is valid because often these people are paying taxes and holding jobs legally. And so I think they definitely should be able to decide on the community.
While age may not be an indicator of ability to comprehend, would you think the fact that the judge gives the instructions and makes a determination on the ability of the person to follow those instructions is a safeguard against what you are suggesting?
I would certainly argue that the judge being able to give instructions when those instructions are given in a fair and comprehensive manner does act as a safeguard on juries maybe being incompetent or unknowledgeable. I would also argue that the process of voir dire allows lawyers to strike and the court to strike jurors who might not understand all of the issues at hand and who might not have a grasp of the issues at hand. So those two things working in parallel with each other really help ensure that a jury is fair and impartial as per the Sixth Amendment.
But at the same time, that really hinges on the fact of if it's a good judge or not. I think that there's a lot of problems with our legal system that has to do with how effective a judge can be. And so a jury not knowing about the law has more to do with the judge than their actual education.
I wanted to switch gears and talk about jury nullification. Do you think jury nullification, oh, you guys are excited about this. Do you think jury nullification has a proper role in our legal system?
Absolutely.
I think that jury nullification is a vital part of our legal system. John Jay said that juries should rule on not just the facts, but also the law. They should find whether a law is just or not. I think that some examples we can point to in American history are the nullification of convictions under the Alien and Sedition Acts, nullification of convictions under the Fugitive Slave Act. This type of nullification helps unjust laws from being enforced. And as such, I think it should be a system that's promoted to overturn unjust convictions.
We do need to be.
Doesn't it create essentially a lawless system? You're allowing potentially one juror to decide what laws should be enforced.
I mean, I would just have, do you all agree with that? With what the opinion just expressed, or is there a dissenter there?
I disagree strongly. I think like a lot of things that were brought by the founders hinged on the fact that when they created the Constitution, when they created our nation, it was only the elite ruling class that was deciding on everything. Laws have become extremely complicated, and I don't think that juries should be able to decide on that. I think that people should elect representatives who decide on laws.
I disagree. There are plenty of unjust laws in our book. We can look at the history of the war on drugs, which was explicitly passed to criminalize the anti-war left and racial minorities in the country by harshly criminalizing drug use. And I think that it's come time for jurors to realize they have this power to strike down bad convictions under immoral laws and should use this power during the nullification against these convictions.
Okay, thank you very much. Thumbs up emoji there. Doesn't have quite the same impact